We'll hear argument this morning in Case 12-144, Hollingsworth v. Perry. Mr. Cooper.
Thank you, Mr. Chief Justice, and may it please the Court. New York's highest court, in a case similar to this one, remarked that until quite recently, it was an accepted truth for almost everyone who ever lived in any society in which marriage existed.
Mr. Cooper, we have jurisdictional and merits issues here. Maybe it'd be best if you could begin with the standing issue.
I'd be happy to, Mr. Chief Justice. Your Honor, the official proponents of Proposition 8, the initiative, have standing to defend that measure before this Court as representatives of the people and the State of California to defend the validity of the measure that they brought forward.
Have we ever granted standing to proponents of ballot initiatives?
No, Your Honor. The Court has not done that, but the Court has never had before it a clear expression from a unanimous State's high court.
Well, this is the concern is certainly the proponents are interested in getting it on the ballot and seeing that all the proper procedures are followed. But once it's passed, they have no proprietary interest in it. It's law for them just as it is for everyone else. So how are they distinguishable from the California citizenry in general?
They're distinguishable, Your Honor, because the Constitution of the State of California and its election code provide, according to the unanimous interpretation of the California Supreme Court, that the official proponents, in addition to the other official responsibilities and authorities that they have in the initiative process, that those official proponents also have the authority and the responsibility to defend the validity of that initiative.
I guess the Attorney General of the State doesn't have any proprietary interest either, does he?
No, Your Honor.
But he can defend it, can't he?
Nor did.
Because the law says he can defend it.
That's right, Your Honor. Nor did the legislative leaders in the Karcher case have any particular enforcement.
Could the State assign to any citizen the right to defend a judgment of this kind?
Justice Kagan, that would be a very tough question. It's by no means the question before the Court, because it isn't any citizen. It is the official proponents that have a specific and carefully detailed.
Well, if you would, on the hypothetical, could a State just assign to anybody the ability to do this?
Your Honor, I think it very well might. It very well might be able to decide that any citizen could step forward and represent the interests of the State and the people in defending.
That would be I'm sorry, you finished?
Yes, Your Honor.
Okay. That may be true in terms of who they want to represent, but a State can't authorize anyone to proceed in Federal court because that would leave the definition under Article III of the Federal Constitution as to who has standing to bring claims up to each State. And I don't think we've ever allowed anything like that.
But Your Honor, I guess the point I want to make is that there's no question that the State has standing. The State itself has standing to represent its own interests in the validity of its own enactments. And if the State's public officials decline to do that, it is within the State's authority, surely, I would submit, to identify if not all, any citizen, or at least supporter of the measure, certainly those that very clear and identifiable group of citizens who are.
The Chief Justice and Justice Kagan have given a proper hypothetical to test your theory, but in this case, the proponents, number one, must give their official address, they must pay money, and they must all act in unison under California law. So these 5 proponents were required at all times to act in unison. So that distinguishes and to register and to pay money for the privilege. So in that sense, it's different from simply saying any citizen.
But of course it is, and I think the key.
But can you tell me that's a factual background with respect to their right to put the ballot initiative on the ballot. But how does it create an injury to them separate from that of every other taxpayer to have laws enforced?
Your Honor, the question before the Court I would submit is not the injury to the individual proponents. It's the injury to the State. The legislators in the Karcher case had no individual particularized injury, and yet this Court recognized they were proper representatives of the State's interests, the State's injury.
At least one of the amici has suggested that it seems counterintuitive to think that the State is going to delegate to people who don't have a fiduciary duty to them, that it's going to delegate the responsibility of representing the State to individuals who have their own views. They proposed the ballot initiative because it was their individual views, not necessarily that of the State. So Justice Scalia proffered the question of the Attorney General. The Attorney General has no personal interest.
True. No.
He has a fiduciary obligation.
The Attorney General, whether it's a fiduciary obligation or not, is in normal circumstances the representative of the State to defend the validity of the State's enactments when they are challenged in federal court. But when that officer doesn't do so, the State surely has every authority, and I would submit the responsibility to identify particularly an initiative.
Why
context.
isn't the fiduciary duty requirement before the State can designate a representative an important one?
Your Honor, I would submit to you that I don't think there's anything in Article III or in any of this Court's decisions that suggest that a representative of a State must have a fiduciary duty. But I would also suggest —
Well, generally, you don't need to specify it, because generally the people who get to enforce the legislation of the government are people who are in government positions, elected by the people.
And, Your Honor,
here, these individuals are not elected by the people or appointed by the people.
And the California Supreme Court specifically addressed and rejected that specific argument. They said it is in the context when the public officials, the elected officials, the appointed officials, have declined to defend a statute that, by the way, in this case, a constitutional amendment, was brought forward by the initiative process. The Court said it is essential to the integrity of the initiative process in that State, which is a precious right of every citizen, the initiative process in that State to ensure that when public officials, and after all, the initiative process is designed to control those very public officials, to take issues out of their hands, and if public officials could effectively veto an initiative by refusing to appeal it, then the initiative process would be invalidated.
Historically, I think, 40 states, many states, have what was called a public action. A public action is an action by any citizen primarily to vindicate the interest in seeing that the law is enforced. I think, yes, now that's the kind of action, I think, that this Court has interpreted the Constitution of the United States, case in controversy, to say that it does not lie in the federal system. And, of course, if that kind of action is the very kind that does not lie, well, then to say, but they really feel it's important that the law be enforced. They really want to vindicate the process. And these are people who have special interests. We found the 5 citizens who most strongly want to vindicate the interest in the law being enforced and the process for making the law be enforced. Well, that won't distinguish it from a public action. But then you say, but also they're representing the State. And at this point, the Dellinger brief, which takes the other side of it, is making a strong argument. Well, they aren't the State. They're really no more than a group of 5 people who feel really strongly that we should vindicate this public interest and have good reason for thinking it. So what you've read all these arguments, you know, they're not really the agent and so forth. Yeah. What do you want to say about it?
What I want to say, Your Honor, is that according to the California Supreme Court, The California Constitution says in terms that among the responsibilities of official proponents, in addition to the many other responsibilities that they step forward and they assume in the initiative process, among those responsibilities and authorities is to defend that initiative if the public officials which the initiative process is designed to control have refused to do it. It might as well say it in those terms, Your Honor.
Counsel, if you want to proceed to the merits, you should feel free to do so.
Thank you very much, Your Honor. My excuse me. As I was saying, the accepted truth, excuse me, the accepted truth that the New York High Court observed is one that is changing and changing rapidly in this country as people throughout the country engage in an earnest debate over whether the age-old definition of marriage should be changed to include same-sex couples. The question before this Court is whether the Constitution puts a stop to that ongoing democratic debate and answers this question for all 50 states. And it does so only if the respondents are correct that no rational, thoughtful person of goodwill could possibly disagree with them in good faith on this agonizingly difficult issue. The issues, the constitutional issues that have been presented to the Court are not of first impression here. In Baker against Nelson, this Court unanimously dismissed for want of a substantial federal question.
Mr. Cooper, Baker and Nelson was 1971. The Supreme Court hadn't even decided that gender-based classifications get any kind of heightened scrutiny.
That's true.
The same-sex intimate conduct was considered criminal in many states in 1971. So I don't think we can extract much from Baker against Nelson.
Well, Your Honor, certainly I acknowledge the precedential limitations of a summary dismissal. But Baker against Nelson also came fairly fast on the heels of the Loving decision. And Your Honor, I simply make the observation that it seems implausible in the extreme, frankly, for 9 justices to have seen no substantial federal question if it is true, as the respondents maintain, that the traditional definition of marriage, insofar as it does not include same-sex couples, insofar as it is a gender definition, is irrational and can only be explained as a result of anti-gay malice and a bare desire to harm.
Do you think this can be treated as a gender-based classification?
Your Honor,
it's a difficult question that I've been trying to wrestle with.
Yes, Your Honor. And we do not think it is properly viewed as a gender-based classification. Virtually every appellate court, state and federal, with one exception, Hawaii, and a superseded opinion, has agreed that it is not a gender-based classification. But I guess it is gender-based in the sense that marriage itself is a gendered institution, a gendered term. And so in the same way that fatherhood is gendered or motherhood is gendered, it's gendered in that sense. But we agree that to the extent that the classification impacts, as it clearly does, same-sex couples, that classification can be viewed as being one of sexual orientation
outside of the marriage context. Can you think of any other rational reason for a state using sexual orientation as a factor in denying homosexuals benefits or imposing burdens on them? Is there any other rational decision-making that the government could make? Denying them a job, not granting them benefits of some sort, any other decision?
Your Honor, I cannot. I do not have anything to offer you in that regard.
If that is true, then why aren't they a class? If they're a class that makes any other discrimination improper, irrational, then why aren't we treating them as a class for this one benefit? Are you saying that the interest of marriage is